right? Yeah.
Okay, that's okay, no problem.
Yeah.
First of all, welcome to this roundtable, and many thanks for being here to everybody. The context of this event is the 6th edition of the EULOS Summer School, the Summer School on European Union and the Law of the Sea, which is an activity which is organized within the Chamonix Chair on International and European Law of the Sea that I have been awarded by the European Commission. The roundtable has become a traditional midsummer appointment in the past years, and also a way to open up to a larger public the opportunity to learn and to discuss the law of the sea matters. To a larger public means that not only, as you can see, the summer school participants for this year are taking part in the public, but the public involved is a larger and more numerous one. This roundtable is usually held at a symbolic venue here in Genoa, either at the Coast Guard headquarters or at the Port Authority seat or at the university. And this has been always intended by me and the other people involved in the organization as a way to expose the international audience of summer school participants to the main players in the field of the law of the sea and of maritime law, locally and nationally. This year, of course, the summer school, the entire summer school, as well as this particular event, went online. As it was felt that it was more important to keep these appointments alive, although in a socially distant format, than to skip them overall. And I'm glad to say that the summer school attracted this year 17 participants from 6 different countries, spanning from Colombia to Lebanon. As I was saying, however, the attendance today is not limited to summer school participants, but is open to other interested parties, including scholars, practitioners, students, and I'm happy to say also some summer school alumni from the past. Before giving the floor to the first speaker, I would like to say a few introductory words on the overall topic. Let me say at the outset that we have 4 outstanding speakers today. I will introduce them later, but I can already say that they will give us a chance to look at the topic that is at the heart of today's discussion from a variety of perspectives, including public international law, and in particular law of the sea and international environmental law, but also international commercial law and European Union law. These are Professor Warwick Gullett, who is connected from Australia, Professor Zou, who is connected from the UK, Professor Fabrizio Marrella, who is connected from Venice, and Professor Chiara E, who is connected from Genova. So a few words of introduction on the overall topic. There are a range of different perspectives from which the One Belt, One Road initiative, this is the official name, launched in 2013 by President Xi Jinping. There is a range of perspectives by which this initiative can be studied. And this is also due to the multifaceted nature of the initiative itself. I think one may safely assume that the main dimensions of the One Belt, One Road initiative are geopolitical and economic. This may be true, but I think that the instruments by which the relevant objectives of the initiative will be pursued will undoubtedly be legal instruments. Equally, many of the obstacles that the One Belt, One Road initiative will encounter in its development are likely to be of legal nature. So it may be a project that is geopolitical and economic in nature, but as many geopolitical projects, as many economic projects will not come to life until it is supported by appropriate legal instruments, and will have to overcome, most likely, legal obstacles in order to achieve its objectives. The problem here is, as most in the audience know, that the One Belt, One Road initiative lacks a legal framework of its own. Some say that this is a transitional situation. Others say that this will not change, and probably nobody knows what the truth is. And the bottom line is that we have to work. We have to work out the impact on the One Belt, One Road initiative of existing legal regimes, and in particular, the existing legal regimes will somehow frame the initiatives that will be conducted within the One Belt, One Road initiative. Many different readings of this initiative exist. What can be said is that its purpose is to increase cooperation between China and countries along the Silk Economic Belt, Silk Road Economic Belt, and the 21st century Maritime Silk Road. And the latter is the one that we are particularly concerned here, as the purpose of this roundtable is to analyze a specific set of implications of the One Belt, One Road initiative, which are concerned with trade occurring by sea. And from here, one can see that there is a need to assess on the one hand, the interactions of the One Belt, One Road initiative with a fundamental principle of the law of the sea, such as freedom of navigation, including freedom of safe navigation and safety of navigation. And always on the one hand, that is from a public international law perspective, there is also a need to analyze the interactions of the One Belt, One Road initiative with an apparently competing or a potentially competing set of values, such as those related to the protection of the marine environment or the protection of the environment in general. In fact, more cooperation between China and partner countries means more maritime traffic and, in principle, more maritime infrastructures. And this is potentially putting under stress both coastal states' interests, and I refer to the interests of coastal states which are located along the Maritime Silk Road, and also their economic and political ambitions, as well as additional stress can be caused to the current state of the marine environment. I'm coming to the closure of this this introduction, and I want to add that, and this is particularly important, I think, to stress on this occasion, public international law is by no means the only relevant viewpoint here. European countries and the European Union as such are expected to play a major role, both as a terminal point of the Maritime Silk Road, but also more in general as an economic partner of China in terms of both inbound and outbound investments, including investment in the transport, maritime, and infrastructure fields. Finally, but also crucial, and thus the need to study the One Belt, One Road initiative also from the viewpoint of European Union law. Finally, but also crucially, the private sector is going to be at the forefront of this initiative, whose success will also, or principally perhaps, depend on the ability to trade seamlessly. Seamless trade seems an oxymoron these days, with the borders being closed because of the pandemic, and with many countries leaning towards isolation and unilateralism. Clarity of trade terms will, however, always be paramount, and this is why a presentation on Incoterms has also been included. Okay, I will. It is now my pleasure to give the floor to Professor Keyuan Zou, or Zou Keyuan, and it is also my pleasure to present him to those who do not know him. He is Harris Professor of International Law at the University of Central Lancashire in Preston, UK. And his areas of specialization are international law, with particular regard to the law of the sea, and Chinese law. He is the author and editor of numerous works in the law of the sea, including on the maritime aspects of the One Belt, One Road initiative. And he is active in many research and advisory bodies, including, for example, the China National Institute for South China Sea Studies, and is also the member of the editorial board of several leading journals. He is a dear friend, and it is therefore, without further ado, my great pleasure to give him the floor. He will speak about the One Belt, One Road initiative and navigation, with particular regard to safety of navigation. Keyuan, the floor is yours.
Thank you very much, Lorenzo, and for your kind introduction, and good day, everybody. And it is really a good day. It's really used in English, and but in other languages, it's very common, like Guten Tag and Bonjour. But because of the different localities of the participants, and good day maybe it's more appropriate. I'm very happy to speak here with you and share my ideas with you. And my assigned topic by Lorenzo is regarding the safety of navigation in the context of the Belt and Road Initiative. So there are some slides, and I'll share with you. And the first thing is, what is Belt and Road Initiative?
Keyuan, sorry for interrupting. The slides are not showing now.
Are you sure?
At least I don't see them.
Okay. Can you see now?
Yes.
Okay. Okay, that's good. And because just now Lorenzo give you an introduction about the Belt and Road Initiative, and also called One Belt and One Road. And this was launched in 2013, and also focusing on the cooperation between China and the countries and around the Belt and Road. And the Belt is the Silk Road economic belt that is land-based. And there's another one, is the ocean-based, called the 21st Century Maritime Silk Road. And this is more related to the law of the sea with regard to the ocean development and the blue economy. So this is a map about the Belt and Road, and you can see there are two roads, one from Xi'an, China to Europe. All the destination is in Europe, but one is on the land and through the Russia, and then goes through the Turkey, then go to Rotterdam, and then another one is the Maritime Silk Road, and from the coastal city from China, then around goes through the South China Sea, Indian Ocean, and the Mediterranean Sea, then go to Europe. So that is roughly the two roads, and this is an illustrated map about the Belt and Road, of course, and in the concept, mainly there are two routes leading the economic connectivity from China to Europe. But broadly speaking, the Belt and Road coverage is worldwide, and also currently there's a discussion about the icy Silk Road. That means a road through going through the Arctic Ocean and up north, but it is not shown on this map. And also, and the initiative engages and the Pacific Ocean countries and Latin American countries. So it is worldwide, actually. So there's a very important meeting which was held in 2017, and then released a document entitled Vision for Maritime Cooperation under the Belt and Road Initiative. And this one is to synchronize development plans and promote joint actions among countries along the 21st century Maritime Silk Road. So this is the very important document released by China, and in regard to maritime cooperation around the belt and particularly along the Maritime Silk Road. So this is a kind of figure I gathered from the relevant information. And as of January 2020, China signed the cooperative documents with 138 countries. And you can see the Africa, Asia, Europe, Oceania, and Central and South America, and 30 international organizations. So there are some countries in Europe, like Italy, Portugal, Greece, and Australia. This is Western Europe, but many are in Eastern Europe. This is kind of relating to the safety of navigation. You can see this is the kind of strategic sea lanes from China to Europe and Africa, and also I can see that it is most of the spots along the South China Sea, Indian Ocean, and also the Red Sea. So that is a very crucial and sea lane connecting Asia to Middle East and Europe. So the safety of navigation always an issue, and regarding to the navigation through sea lanes, such as the South China Sea, which is essential for world seaborne trade and communications. And this is the kind of shipping, regarding the shipping industry. And another factor which is also very essential to safeguard the safety of navigation is territorial and maritime disputes existing in the relevant seas, and which would affect the smooth move of the shipping. So navigation in the international context, and we will know that in international law, freedom of navigation is the principle, and that is for a long time accepted, universally accepted by all countries in the world. And it was first incorporated into conventional international law, and like in 1958 Convention on the Law of the Sea, and this is before the UNCLOS, the 1982 Convention on the Law of the Sea. So at present, the navigational rights of vessels are mainly governed by the UNCLOS and also LOSC, and that is the abbreviation for the UN Convention on the Law of the Sea, which was adopted in 1982 and came into force in 1994. So the laws, the Law of the Sea Convention has made legal arrangements for navigational rights of foreign vessels in accordance with different sea zones established under the convention. So sea zones of territorial sea and EEZ. EEZ stands for Exclusive Economic Zone, are particularly related to navigational rights of foreign vessels within national jurisdiction of a coastal state. And there are three matters which are important in terms of safety of navigation. And one is the right of innocent passage, which is exercised within the territorial sea of a coastal state. And the basic concept is that you can pass any vessel, and you can pass through the territorial sea without anchoring, without stopping, and without endangering the peace and the stability of a coastal state. So that is the basic concept. But there's also controversial issue relating to the warships, and whether warships can enjoy the right of innocent passage. And the state practice in this respect is different. And while majority of the states recognize the right of innocent passage applicable to the warships, some states like China then requires the warships to get a prior approval, advanced approval, before entering into China's territorial sea. So that is the kind of qualified the limitation to the movement of the warships, and also challenged currently by the United States and also opposed by Western countries and like the United Kingdom. And then the freedom of navigation in the EEZ, and this is kind of remaining rights, and because the EEZ is relatively new concept in the law of the sea, and when it is established, it can extend 200 nautical miles from the baselines of a coastal state. And freedom of navigation, and used to be the freedom of high seas, still can be applicable in the EEZ. That is the kind of remaining rights existing in the EEZ. Of course, EEZ is a sea maritime zone of within the national jurisdiction. But the other aspect is the due regard. And if you exercise the freedom of navigation EEZ, and you need to exercise the due regard, and do not excessively use the freedom of navigation, and in the context, for example, and you exercise the military maneuvers in the EEZ of a coastal states, that will be a kind of disturbance against the peace of a coastal state. So that will be some countries and adopted domestic laws to restrict the military activities of foreign countries in their EEZs. So some kind of Chinese regulations, and you can see that Chinese regulations, and one is the Law on the Territorial Sea and the Contiguous Zone, which was adopted in 1992. And this is kind of very important law in compliance with UNCLOS, and also the law on the EEZ and the continental shelf, which was adopted in 1998, and other laws like law on maritime traffic safety, regulations governing supervision control foreign vessels, and regulations governing non-military foreign vessels passing through the Chungzhou Strait. All these, and also many others, and also relevant to the safety of navigation within China's within the waters of Chinese national jurisdiction. And you can see that just I mentioned that regarding the innocent passage, and in Chinese regulations, foreign ships for non-military purposes enjoy the right of innocent passage. And foreign ships used for military purposes are subject to permission from China before entering the territorial sea. And also the third point is foreign submarines and other underwater vehicles, when passing through the territorial sea, should navigate on the surface, show their flag. That is in conformity with the law of the sea provision. And but the first one, and it's the second point is controversial, and because it is not expressly provided that you can let down such kind of domestic regulation restricting the foreign warships into your territorial sea, enjoying the innocent passage. So that is controversial, still controversial. I don't know whether there will be a uniform rule after the amendment of the law of the sea convention. Then China, that is also relating to the innocent passage. I just skip it, and this is the law about easy and the continental shelf, and then according to this, and all foreign vessels, including warships, can enjoy the freedom of navigation in China's EEZ, provided that they comply with the relevant Chinese laws and regulations as well as international law. So that is in conformity with the law of the sea convention. And you can exercise the freedom of navigation, but on the other hand, you should show your due regard. So this is the other one is about the EEZ law also provides that China should have the right to take necessary measures against violations of Chinese laws and regulations, and to investigate, according to the law, those who are liable and may exercise the right of hot pursuit. So this is kind of measures China can take. Then I move to another one. It is very, very, very crucial regarding to safety negation is a policy issue, and the policy, and it's a kind of long story, and you can see the Caribbean Sea and the movie, and about the policy, and but in the real world, policy is existing, and even today, and so the policy issue is still very, it's a serious issue, and threatening the safety of navigation globally. So there are two international instruments, international treaties, which are governing the suppression of piracy, and one is the UNCLOS, the Convention on the Law of the Sea. The second one is a convention for the suppression of unlawful acts against the safety of maritime navigation. That is also very important. So the first one is possibly relatively popular, more popular, and the second one is more technical in terms of suppression of because it is suppressing the unlawful acts, not only regarding to policy, but also many other unlawful acts against the safety of maritime navigation. So we look at the UNCLOS first, the UN Convention on the Law of the Sea, and accordingly, and the convention established an obligation for states to cooperate in the suppression policy and grants states certain rights to seize pirate ships and the criminals. So that is the right and the convention gives to all the states to punish the pirates. And Article 100 provides that all states shall cooperate to the fullest possible extent in the repression of piracy on the high seas or in any place outside the jurisdiction of any state. So this one is a kind of it is a kind of problematic in front of the current situation of piracy around the world, because this one is limited the repression of repression of piracy on the high seas or in any other place outside jurisdiction of any state. But if you look at the development of the law of the sea, and I just mentioned the EZ, and because the EZ extension of the maritime zones of national jurisdiction, and this kind of high seas perception may not be very effective in suppression of piracy. That is the problem. So the second convention is the Suva Commission, that's the 1988 Suva Convention, and that means applies to all maritime terrorist acts, whether private or political. So the significance lies in that if terrorist acts will not be punished and suppressed under the law of the sea convention, they are still under the suppression of the Suva Commission. This means that any maritime terrorist and political act cannot escape justice. So this is both to whether it is private, but in the law of the sea convention, that means piracy. The purpose of piracy is for private purposes. But this one and applies to all maritime terrorist acts and piracy. So that is the coverage is much broader than the law of the sea convention. So there are also some regional arrangements regarding the suppression of piracy, and you can see that in Asia there are 3 documents, and one is the 2002 Joint Declaration of Cooperation in the Field of Non-Traditional Security Issues. And this one is signed between China and the Association of Southeast Asian Nations, ASEAN countries, 10 ASEAN countries. And the second one is the Declaration on the Conduct of Parties in the South China Sea. Both of these documents mention the suppression of piracy, and this is the issue is within the category of cooperation between the two sides. And the most significant document which exists in Asia is the 2004 Regional Cooperation Agreement on combating piracy and armed robbery against the ships in Asia. So that is the recap. So recap is very significant. It is legal in comparison with the above 2 documents. It is a legal document. It is a treaty. But for the first 2 are the political documents and may not be having kind of legal effect. So the recap, the regional, it was adopted on 11th November 2000 and came into force in 2006. And then there was the Information Sharing Center, which was officially launched in Singapore in November 2007. So the center is now in Singapore. And there are several characteristics and about the recap. It is not exclusive. That means any other countries also can join the agreement, no matter whether it is an Asian country or a European country. So currently, like Norway, United Kingdom, and some other countries also signed this agreement. And Secondly, this is the first specific international treaty concerning the prevention and suppression of piracy. So before that, and because Law of the Sea Convention, it is several articles of the convention mention the suppression policy, but it is not a specific treaty. It is the Law of the Convention and governs various aspects of the oceans. But this treaty is a specific treaty concerning the policy. So that is very significant. And then the Information Sharing Center in Singapore, that is governmental international organization, because before that, and the International Chamber of Commerce, they have the International Maritime Bureau, and they set up information sharing center in Kuala Lumpur in Malaysia. But that one is because the International Chamber of Commerce is not a governmental international organization, so that is so it's different. Now currently the ISC, which is established under the RECAP, is a governmental international organization, so that is different from the one in Kuala Lumpur. And also it contributes to the legal definition of policy, and because of the time, and I can't unfold too much about the discussion about the definition of policy, but maybe we can discuss later in the Q&A. Then there are further developments regarding the suppression policy, and this one is also very significant because of the involvement of the United Nations Security Council. And in June 2008, the Security Council passed a resolution about the policy and of Somali waters. That is Resolution 1816. So that one is the first time, and the United Nations Security Council regarded the policy issue as a matter threatening the world peace and security. So that is that means that the policy issue is leveled to a very high degree, and treated as a matter such as a war or armed conflict, or kind of great humanitarian crisis, something like that. So that is very significant, and the resolution, and then the latest one, and because of the resolution and the continuation efforts of the international community to combat the piracy in Somali waters, so this is a kind of renewable resolution extended almost several years. So the latest one is last year, December, extended further period of 12 months in Somali waters. So that is still continuing, and the resolution, this is a continuation of the resolution 1816, and to combat the piracy in Somali waters. So that is the one point I would like to mention is the UN Security Council resolution is different from the UN General Assembly resolution, because some of the UN security resolutions, they have legal effect, particularly the resolutions passed under Chapter 7 of the United Nations Charter. Then I mentioned China's position, and because China and also support the UN resolution, and also China in January 2009, China decided to send warships to Somali waters and join the international efforts to crack down on Somali piracy. So far, Somali piracy is now it's reduced very much. but in other areas like the Gulf of Guinea and some other places, resurgence. So this just like the pandemic, sometimes with the deterrence, it is coming down. Then when you release the lockdown, then it is up again. So this is kind of policy. It's also up and down. So recently, and also policy in Southeast Asia, in the South China Sea, also it's kind of resurging again. So this is of course, there some people attribute this kind of up and down to kind of roots issues like poverty and deprivation of the livelihood of fishermen, other various factors. So then this is a kind of task, naval task. So of China to Somali waters. So this is the first time that Chinese warships went overseas, to Indian Ocean. So that is the first time. And then I moved to the second part of my talk about the maritime claims, and also this kind of disputes, territorial disputes, maritime disputes existing in the seas, which would affecting the safety of navigation. So because of this convention and the national inclusion of maritime spaces have been intensified, because every coastal country, they can extend their maritime zones according to the convention. So this is the second point is you can see that an island which cannot sustain human life can have its territorial sea of 1,550 square kilometers. So this is the kind of island. This is according to Article 121 of the convention. But a big island which can maintain economic life or human habitation can obtain its easy of about 420 square kilometers. You can see how big the extension is regarding to the maritime zones from an island, of course, and for continental countries, and they can extend their maritime zones from the coastline of the continent. So that is for sure. So you can see this one, and that's why there are disputes existing, and this is the dispute between China and Japan in the East China Sea, and the island called Diaoyu in Chinese and Senkaku in Japanese, and this is also pending to resolve. And this is the island. So this is a barren island, and there's no habitation. I don't think there will be economic life either. But the problem is, and the two countries, or both claim the ownership of the island, and so this kind of very thorny issue in the bilateral relations of the two countries. So because of this, and in addition to the island issue, there's also the maritime boundary claims because of the EEZ and the continental shelf, and Japan. Their position is the middle line between China and Japan. And China claims that we should extend our continental shelf to the Okinawa Trough. So that is based on the principle of natural prolongation. So that is kind of conflict positions between the two countries. And then the locations here is the kind of China's gas fields, just very close to the Japanese claim, the middle line claim, but also Japan protested because it is too close to the middle line, and according to the kind of siphoning theory, and China could extract the oil and gas from the localities which may belong to Japan. So that is issue in the South China Sea. Then you can see that is issue in the East China Sea. Then we move to the South China Sea. That is even more complicated, because there are 5 countries and 6 parties that involving in the disputes, like China, Taiwan, Malaysia, Vietnam, the Philippines, and Brunei. There are 6 parties for the 5 countries, because according to the one China principle, Taiwan is regarded as part of China, but Taiwan is currently is a kind of entity independent of the Chinese governance. So this is a map showing the overlapping claims, and you can see that this is a kind of Chinese claim and the other claim, and it is very complicated. A lot of lines within the South China Sea, and this is kind of overlapping claims, and and this is the Chinese claim, and about the U-shaped line, and also known as a 9-dash line. And you can see that this claim almost all the waters within the South China Sea. But the issue is the line is not well defined, and whether it is the line claiming all the islands and features within the South China Sea, or even including waters. So it is not very clear, and also so far the Chinese government has not given a very definitive answer to this kind of ambiguity. Then kind of maritime boundary delimitation issues, and China has maritime boundary with 8 neighboring countries, and like Korea, North Korea, South Korea, Japan, Philippines, Brunei, Malaysia, Indonesia, and Vietnam. And so that is so far there's only one maritime boundary delimitation between China and Vietnam in the Gulf of Tonkin and the Beibu Gulf, and that is concluded in 2000, and that is only one boundary agreement, a maritime boundary agreement between China and Vietnam. But for other boundary delimitations, they are still pending, subject to further negotiations. And this is the different claims now in the East China Sea, and I just mentioned. So any solutions regarding to the territorial maritime disputes, there are possibly 3 solutions. One is joint development, the second is third-party dispute settlement, and the third one is regional cooperation. So in South China Sea, and you can see that in November 2003, and then the Chinese state-owned company CNOOC and the Philippine National Oil Company, they agreed to jointly explore oil and gas in South China Sea. That in 2000, and then in 2005, Vietnam also joined. So they three parties, they signed an agreement on joint seismic survey activities in South China Sea. So this one is kind of location of the joint area in the South China Sea, and this is a very good agreement. But unfortunately, and after 3 years of the first phase of exploration, and this agreement was suspended, and there's no further progress. So that is actually the agreement is dead right now, and particularly with the intensified situation in the South China Sea. Then the East China Sea, there's in 2008, China, Japan, they signed the consensus agreement. They call the principled consensus, and I don't know, because they use a very interesting name, principled consensus. Whether it is some people say that it is agreement, some people say it is not, because it is only a consensus. So there's three main points, and one is bilateral cooperation in the East China Sea and turning into a sea of peace, cooperation, friendship. So this is a kind of rhetoric. And the second one is joint development in the East China Sea, and a small patch of joint development zone has been identified. And the third one is participation of Japanese legal person in the development of Chunxiao oil and gas field in accordance with Chinese laws. So this the last 2 points are more specific. Then you can see that the joint zone and is in the middle of the East China Sea, but very, very small and insignificant. But even for this kind of arrangement, and currently is suspended because of the some people in China, they are not satisfied. They said that if we implement this kind of joint development, it would be sell the Chinese rights to Japan, and so that be very even more complicated. Joint development, it is a solution, but it is not easy to implement. Then we move to the third-party dispute settlement, and of course we can see that China is very reluctant to resort to any third-party settlement mechanism, and prefers negotiation consultation. That is, can see that China rejected the South China arbitration, and did not participate, did not recognize, and so that is reflected Chinese position. And also China in 2006 made a declaration and exclude some of the matters disputes from the Law of the Sea Convention's dispute settlement mechanisms. And that is regarding to the maritime boundary delimitation, historical rights, military activities, and other things. So that is China exclude all these, because according to the law of the convention, you have to accept the one of the 4 compulsory dispute settlement mechanisms, including International Court of Justice, the International Tribunal for the Law of the Sea, arbitration, or special arbitration. And even if you do not declare any of the mechanism, then you are deemed to have accepted the arbitration. So that China did not declare to accept any of the mechanism. So China is deemed to accepted the arbitration mechanism, but China refused to participate in the South China Sea arbitration. So then we move to the regional cooperation, and this one is relating to the South China Sea as well. And this one is significant and document, but it is political document, but it's guiding guidelines. And then adopted in 2002, just as I mentioned, and they intend to cooperate in the following matters, like maritime environmental protection, maritime scientific research, safety of navigation and communication at sea, search and rescue operation, and combating transnational crime, including trafficking illicit drugs, piracy, armed robbery at sea, and illegal trafficking arms. So all these cooperative areas that China and ASEAN countries they can undertake. Then recent U.S. military activity in the South China Sea, that is kind of currently also reported in the mass media. And since Donald Trump, the U.S. naval exercise in the South China Sea have been intensified. By 2018, 6 FONOPs had conducted, including the FONOP Freedom of Navigation Operations that was conducted by the U.S. American Navy, and conducting including 3 entering into China territorial seas, the Spratly Islands. This is the 6th. You can see that, and then you can see that this is in 2019, last year. 2 U.S. Navy guided missile destroyer conducted freedom of navigation operations in South China Sea, and also this is a 3rd such operation in the South China Sea. Then 2020, this year, and continued. The FONOPs continued, and the first one this year is January 25th by sending the littoral combat ship Montgomery past China's claims in the Spratly Islands. So this is the 2020, and also Ye Qiang helped me to prepare these slides. You can see this. This year is only 1, 2, 3, 4, 5, 6, and I just came across the news today and yesterday, and the U.S. Navy conducted another military exercise, military operation around the Plateau Islands. So far this year, there are altogether 7 operations. So you can see that this kind of freedom navigation. I just finished. I just possibly 2 minutes, and freedom of navigation operations and intensified. It's more frequent, more threatening, and more confrontational. So this is kind of slugs in the South China Sea. You can see this is kind of sea lanes in the South China Sea, and of course, and this kind of military frequent and intensified military operations by United States definitely can pose increasing risk and threat to the safety of navigation. So how to diffuse kind of threat, we don't know, because United States is deliberately want to trick kind of conflict, armed conflict with China. So this is kind of a very dangerous signal from the United States. Okay, some conclusions. And one is the UN Convention established a rule of law regime for the oceans and the compliance with international one of the requirements when states interact and cooperate in international relations. And in order to maintain harmonious maritime order, it is important to strengthen the international rule of law within the Law of the Sea Convention as a legal basis, with the Law of the Sea Convention as a legal basis. Secondly, there should be a caution for foreign vessels navigating in and through disputed waters due to the unclear maritime boundary delimitation between countries concerned. If there's a tension conflict between claiming states in disputed restricted areas, then the normal navigation ought to be unnecessarily hampered. As the shipping is a key element in the execution of the BRI, the Belt and Road Initiative, the safety of navigation along the road should be guaranteed through joint effort between China and participating countries by working out a viable and rule-based mechanism towards the reach of common property for the whole international community. Just as Lorenzo mentioned, that there's no kind of legal framework. That's an initiative, but there's no legal framework governing the Belt and Road. So that will be kind of future work and between China and other countries, and for working out a kind of legal work. Finally, I'll introduce you two books and regarding to the BRI and the maritime security. The first one is the 21st Century Maritime Silk Road, and I edited, and Ye Qiang and Wu Sichun. He's the president of the National Institute for the South China Sea Institute. And this one is regarding the Maritime Silk Road. And this year, the new book, The Belt and Road Initiative on Law of the Sea, is published. And also some of the speakers like Professor Warwick Gullett also contribute a very significant chapter to this book. So if you are interested, and you can make a reference to your further studies. Okay, I just stop here, and thank you for your listening.
Thanks a lot, Keyuan. And I didn't want to interrupt you, although you were going a little bit over time, because I mean, you know so much about this issue that it's always very good to hear from you. And I'm sure that there will be an opportunity for additional reflections from your part during the Q&A session. In fact, I would like to proceed in the following way. If there is any question from the audience requiring an immediate answer, a question which is specific to what Professor Zou Keyuan just explained, we can take such question now, and you are welcome to use the chat function or the hand raised function to make yourself known to me. Otherwise, if you would like to make a more general contribution to the discussion, or you have a more general question, you can leave such question or such contribution for the let's say for the time which will be left after the 4 presentations. So I'm giving you a few seconds to make yourself known. But if there is no body willing to take the floor, then I will move to the second presentation of today. This is from Professor Warwick Gullett. He's in Australia right now. Warwick is a professor of law at the University of Wollongong, Australia. I'm proud to say that this is a university which has a student exchange agreement with the University of Genova, which allows students from either university to visit the partner university for a semester of study. Warwick has been also in the past the Dean of Law in Wollongong. He is also in the academic staff of ANCORS, which is the Australian National Centre for Ocean Resources and Security, of which he has been a deputy director and an acting director. Professor Gullett's research focuses on the law of the sea, with particular but not exclusive regard to marine environmental law and fisheries. And in such areas, he has written extensively, including a book on fisheries laws in Australia. Professor Gullett's work has been cited by several judicial authorities, including the International Tribunal for the Law of the Sea. His presentation today will focus on the Belt and Road Initiative and marine environmental protection. Warwick, you have the floor, and thank you for being with us. We cannot hear you if you're speaking.
Okay, can you hear me now?
Yes, we can.
And hopefully you can see me soon too. So Professor Lorenzo, can you just confirm you can hear and see me and my PowerPoint slide?
I can confirm your identity.
Okay, great. So I'll start now. Buongiorno, everybody. I think it is the morning for most of the participants, but as Professor Lorenzo said, I'm here in Australia, so it's actually the evening time. So it's a pleasure to be involved in this forum. And that was a wonderful start to this session, explaining about the issues for the Belt and Road Initiative and focusing on the maritime components. So what I'm going to look at in this presentation is the BRI and give consideration to opportunities, I guess, and challenges for marine environmental protection. As Professor Lorenzo has already explained with this initiative, it's about increasing cooperation between China and other countries along the different routes, and involving a large amount of infrastructure development. So if we're trying to look at the marine environmental protection issues, we can try to look at what projects have been proposed, and are they going to enhance marine environmental protection or otherwise present a risk to marine environmental protection, and not just the projects themselves, but how they will help or facilitate larger scale shipping. And as Professor Lorenzo has already mentioned, this is one thing that we're likely to see with the BRI is increase in shipping. And if we just start with that, I think we can conclude that that is a good thing for the environment, because transporting goods by sea is one of the most environmentally efficient means of transporting goods rather than land-based routes or air. So at the larger scale of increased maritime traffic will have greater environmental risk, but overall it's a good way to transport goods. Now the BRI is not something that I think that we should look at as simply China being very generous and magnanimous to all the other countries that have signed up to it. It is something that China is doing to cooperate with other countries, but obviously it's in China's strategic interests, and its long-term strategic interests. So I think we need to look at the BRI as China making significant investments in ways that should be of benefit to those countries, but also is advancing China down a path that it wants to go down. But if we're looking at the large amount of money that has been put into different development projects, a lot of that money, of course, would be of a benefit to the host countries, but a lot of the work that's being done is by Chinese state contractors. So there's some clear indicators that the investment that's being done by China is for the purpose of not just benefiting the host countries, but China's longer-term strategic interests. So let's now look at the marine aspects of the One Belt and One Road. So this is what I want to go through in this this session to outline the maritime dimension of the BRI, and Professor Zou has already explained the main maritime Silk Road, but there are two others that are emerging as well into the South Pacific and across the north, the polar Silk Road. So I want to briefly overview the three maritime Silk Roads, and then say a few words about the larger international law and international policy context for marine environmental protection. So trying to combine the idea of the BRI and what we need to be thinking about when we want to be making sure that activities are done in a way that's not going to present a risk to the marine environment. And then we can look in a little bit more detail about what is actually happening on the ground, or let's say on the water, with the BRI. So the green credentials, so some of the good things that we can draw out of the BRI. And also I'll give some comments about some areas that we need to, that could be a bit challenging for marine environmental protection. So that's the structure for this part. So we had a similar map to this already presented by Professor Zou of the main Maritime Silk Road, and this is starting off from the east coast there of China, heading through the critical area of the South China Sea that Professor Zou has already discussed, and obviously going through a critical choke point here in the Strait of Malacca. It's connecting with various countries around here. I'd highlight Myanmar. China's been having significant engagement with Myanmar, and then down here through, well, actually also India, but in particular Sri Lanka. Sri Lanka is in a strategic location if we think about transporting goods between Europe and Africa and Asia. Then also up in Pakistan, and all the way down through the Suez Canal. And so, and the map that Professor Zou had also mentioned Kenya. So China's been heavily focused on Kenya, and also another country here, Djibouti, where the Chinese PLA has established a military base, and this sort of protects the approach into the Suez Canal. So that is a route for transporting goods between Europe and China. So then we have this map here is, I'm just showing to be a little bit different, just simply because it has this other Maritime Silk Road that apparently stops about here, but on this map, and this is heading into Oceania. So heading down towards Australia, to places like Papua New Guinea, Vanuatu, Solomon Islands, and so on. And this is another area of strategic importance for China, increasing its influence in the South Pacific region and all those small countries in that area. And Professor Zou mentioned just before, China has already signed 138 agreements or MOUs of some form with countries concerning the BRI, and he mentioned that one of these is Australia, and that is true. Australia signed an MOU back in 2017, but it was a very soft type of agreement, very just bland terms, where it was simply agreeing in principle for Australia and China to cooperate with investment infrastructure in other countries, so not for activities within Australia. And actually just yesterday, our federal government announced that it's going to have more scrutiny of any agreements any government agency, including our provincial agencies at the state level, have with any other country. Of course, it would be, they would have in mind the BRI. So there's going to be increased scrutiny by Australia for any type of actions that are involving the BRI to make sure that they meet Australian national interests. So the South Pacific is an important area for the BRI. Then there's another maritime dimension, the Polar Silk Road or the Ice Silk Road. And so this map here is showing it starting off perhaps here in Dalian, coming up through between South Korea and Japan, all the way through the strait here and around Russia and Scandinavia into Europe. Now, this is a very important pathway for China because it provides another avenue to have goods shipped into China and exported from China, rather than going through perhaps more contested waters through the South China Sea, the choke points, the Suez Canal, and so on. Now, this map actually looks like the Polar Road is longer, but that's because of the distortion of the curvature of the Earth. If we look at a slightly different map here, it helps a little bit more. So again, we've got Dalian over here, the Polar Road going through this way across the Arctic. And so with the polar ice caps melting, there's more opportunity for shipping through this very sensitive environment. And there are actually three potential routes, the eastern, the western, and the central route. And of course, this route over here, hugging along this coastline, is heading over to the east coast of the US. And this route would actually shave around 15 days off the shipping time from Dalian to New York. So China is not an Arctic state. It doesn't have territory in the Arctic, but it is very much focused on this region. And I would say largely to see how shipping can occur in this area in a way that could be beneficial to China. And of course, this is an area that's of great environmental sensitivity. And if there were to be any shipping hazard, this is an extreme environment in which to effect a rescue or to clean up the environment. So the environmental standards for this area is of key concern to the Arctic states. Okay, so now a few words about international law expectations concerning the marine environment. And I've just got one slide here with just perhaps the main type of agreements or areas that we need to have consideration of. And the first one is the UN Law of the Sea Convention, which Professor Zou has already mentioned, the most important international agreement dealing with ocean law. And that has an entire part devoted to the protection and preservation of the marine environment. So even though the convention has some fairly general, nice sounding sort of general obligations, over time they have been amplified to a degree or articulated really in further detail in a handful of international court cases. So we're having developing international jurisprudence about what the standards are under the Law of the Sea Convention. So we've got wonderful overarching objectives and obligations, and then some more detailed procedural matters. So I'd say a key thing under Part 12 is that it puts a key obligation on states, all states in all marine areas, to protect and preserve the marine environment, only balanced by their sovereign right to exploit their own natural resources pursuant to their own environmental policies. So we have a strong objective balanced by sovereign rights. That sounds quite hard to work out the actual detail, but we're having that fleshed out to some degree by jurisprudence. But beyond that, there are some more specific obligations, such as to take all measures that are necessary to prevent, reduce and control pollution of the marine environment. That's Article 194. And that extends to all marine areas. And a key thing throughout the convention is to cooperate with other countries, including on a regional basis. And also noting that there are various procedural requirements. So international cooperation comes up in many instances in the convention, that there's a requirement to notify other states if there's damage to the marine environment. There's an obligation to develop contingency plans for oil pollution incidents. There's obligations to conduct marine scientific research and exchange information. And if there are any, where a state has reasonable grounds for believing any planned activity under their jurisdiction, then they need to, as far as possible, assess the environmental implications of that and communicate reports of that investigation to other states. So this is Article 206, which is a critical one. So where any state under its has reasonable grounds to believe that any activities it plans to do within its jurisdiction could have substantial pollution or significant harmful changes to the marine environment, then it has to go through a process. There's also in the Law of the Sea Convention explicit recognition of rare and fragile ecosystems, different types of habitats, the danger of introducing alien species to new environments, the need to avoid causing transboundary pollution, and also some special consideration for ice-covered areas. As far as the procedural aspect, a key area is the expectation that environmental assessments are completed for certain levels of activities, and that states go about their business with due diligence. So the marine environmental law expectations are quite strong within the Law of the Sea Convention. Now, as I said before, these have been amplified to some degree by slowly developing international jurisdiction. Through a number of cases, including through the International Tribunal for the Law of the Sea, and one of the more recent ones, the Philippines-China arbitral decision that Professor Zou mentioned that concerned the South China Sea. Now, and look at this, I'll put down here that this 2016 case, and Professor Zou mentioned that China was not involved in this case, how it went through the compulsory dispute resolution mechanisms of the Law of the Sea Convention, and it's well known that China did not agree that the arbitral tribunal had jurisdiction over the matter and did not participate. But nonetheless, due to the compulsory nature of that dispute resolution mechanism, the case proceeded in the absence of China's participation, and an award was subsequently issued. The main focus people have had on that case has been the comments out of that case concerning China's claim to the South China Sea, the 9-dash lines that Professor Zou discussed, and also the issue about whether insular features meet the requirements for a fully fledged island to have the full maritime zone. Again, Professor Zou took us through that. But another aspect of this case that hasn't received so much attention was the ruling by the arbitral tribunal that China was in breach of its obligations under the Law of the Sea Convention with respect to marine environmental protection, with regard to its activities around those various features in the South China Sea. So with regard to fishing practices and with regard to construction activities on those features. So, and this is important, I guess, really for two reasons. One is it's an important decision to help still develop jurisprudence about the interpretation of the UNCLOS marine protection provisions, but it also is a record of China's conduct on those particular facts. The IMO, the International Maritime Organization, Polar Code, the Arctic Council have a number of measures, guidelines, legal measures as well, to try to have the highest standards possible for activities in the polar region. So these are things that China would need to be involved with its further engagement in the polar regions. Oil pollution preparation and response. There are a number of agreements where countries need to make sure they've got they are prepared for any oil pollution incident, and they've got resources to bring to bear and to cooperate with other countries in trying to address a marine pollution incident. And all these things we need to be thinking about with the BRI, with the massive increase in shipping, particularly in some sensitive environments. We also have the whole regime of port state control and the expectations of port states that they're inspecting foreign ships when they come into port to make sure they comply with international standards. And a couple of days ago, Mr. Jacob Turling discussed this really well, this very important area of port state control. So this is something we need to be thinking about with the BRI, with a greater international shipping activities taking place, and perhaps in new ports or some ports in some, I say, smaller countries that are expanding significantly due to Chinese investment. So having the other type of infrastructure around those ports for the inspection regime is important, and it's a key objective to make sure that if a ship comes into one port, the inspection regime it will face is equivalent to a port in another country. And I've just mentioned here MARPOL, including so marine pollution, including Annex 6 air pollution, that this is a highly technical area of regulation of shipping. Air pollution is one of the areas that's been focused on a lot in the last few years, and all these ship inspectors require extensive training in order to be able to make sure they do a good job when they're inspecting the foreign ships when they come into port, to make sure that they comply with these standards. And just briefly, other sort of marine environmental issues we need to be considering. Fishing is one of the major activities at sea, and China's heavy involvement in fishing, including in faraway seas. And if we're thinking that a main part of the BRI is investment in other countries to get projects underway to boost their economy, to boost trade and so on, well, there's a whole international framework of expectations that foreign investment will be done in accordance with sustainable development principles. So the UN has been pioneering this, so with various documents creating expectations that if entities in one country do investments in another country, a host country, well, they'll be doing so in accordance with sustainable development objectives. So this will be a key expectation of Chinese investments along all the maritime Silk Roads. Okay, so let's have a look at the green credentials of the Belt and Road Initiative. So one thing I've been very pleased about is that there's a lot of documentation about the BRI coming from the Chinese government. And there are websites that are in English, they're all in very good English with many documents available that are explaining the process or the expectations that China has about the various investments that it will make. And the various documents, I've just listed one here, the Vision for Maritime Cooperation under the Belt and Road Initiative. There are a number of very impressive statements made in documents like this, such as China committing to the UN Sustainable Development Objectives, about how it's going to be doing investments, about committing to green investments, committing to the UN's agenda for coasts and oceans. So in the policy documents that have been released, the English translations of them, I think they're basically saying all the right things about the standards that China is setting for the investments that it will undertake. So that is encouraging. So China's committing to green development. It's committing to support the blue economy. It's stating its commitment to meet international standards, and it has got various documents, including guidelines for the sustainable infrastructure. Guidelines of sustainable infrastructure for Chinese international contractors. So that's quite an important document. I'd mentioned just before that a lot of the development projects being undertaken in the various countries, a lot of money is being spent by China, but a lot of that money is also going to employ contractors, and they are Chinese contractors, but they are expected to meet these standards set by China for sustainable infrastructure. So let's have a look at the type of marine-related infrastructure developments that China has proposed as part of the BRI. And I've taken this list from pulling together parts of different Chinese government documents about what they envisage for the BRI. So first I'll say it's that they canvass quite a few different type of projects, some that look to be very good for environmental reasons, such as committing to develop marine renewable energy projects. So this could be offshore wind farms and commitment to developing projects that will harness the power of the ocean, so tidal power, thermal power, and so on. What's much harder to find is actual examples on the ground where this has happened or in which countries it is being earmarked for. But nonetheless, there's a Chinese government stating that these are the type of things that they're envisaging doing under the marine BRI. I put here first port expansion, which would seem to be the most important one, to invest in various countries to support development of ports of strategic benefit to China. So that will help with the development of trade, but also, if taking perhaps a more critical eye among some of the commentators, whether it's establishing what's known as a string of pearls across the ocean of different ports where the Chinese Navy can operate more effectively. So China has developed a number of ports in strategic locations, 2 extensive ports in Sri Lanka, in Pakistan, in Djibouti, in Vanuatu, and other places as well. Submarine cables, telecommunications. You would not be hearing from me in Australia right now if we weren't using submarine cables. So this is an important infrastructure that continually is being developed in the oceans. There's also a commitment to develop a clean energy grid network, that should be network, for countries closer to China to develop sharing of avenues for energy drawn from green sources. Another one is desalination plants that can work very well. China has experienced over 100 desalination plants within China, and that includes some in the South China Sea for some of those small insular features. Commitment to mariculture. So mariculture is simply marine-based aquaculture, and the need to do that is very important to secure fish protein. Commitment to fish processing facilities, marine tourism, marine surveys, and larger industrial parks for the maritime sector, so building the maritime sector. And I put here in quotes, demonstration projects for developing the blue economy, without me actually being able to find out any more detail than that. So we have a number of different types of activities that could be beneficial, but in trying to find out what has actually happened on the ground so far since the BRI was established, it is difficult. Some projects, there is information about them, but they tend to be just very brief descriptions. So some of the progress to date. So we have the Asia Pacific gateway here, submarine cables going through this area in cooperation with these various countries. Although it is also a little bit difficult to work out which projects are under the BRI and which are just other projects that are subsequently being badged as part of the BRI. So this was underway quite some time ago. And this communication network is over 10,000 kilometres long. The development of various ports around the world, and I'll show a couple of pictures in a moment. The marine industrial plants, desalination plants, and with offshore wind farm, the only one I could find was with Chinese investment was the Netherlands. So I'm not sure whether that's part of the BRI or whether that would be a bit of a test case for offshore wind farms elsewhere on the Maritime Silk Road. So this is perhaps one of the largest infrastructure developments for the BRI that we can find, and this is Colombo, the capital of Sri Lanka, and this is what you can see, essentially an artificial island that's absolutely enormous, right next to the downtown area of Colombo. So a lot of these buildings were built by Chinese money as well. This area, if you can see my cursor along here, this is a beach area, the main strip really of Colombo. I've had the pleasure of being in this area here and saw this part being constructed. So this is obviously a vast amount of money to do something like this, and Sri Lanka, with its strategic location, can be very beneficial for China. There could be some other discussions that others might have a bit later on about the whole nature of this investment and whether it creates a debt burden for the host countries. But nonetheless, we're showing a very large development that is going to be a retail precinct, a residential precinct as well, and there's the expectation there's going to be a large-scale investment from other countries as well to develop this part further. So Arctic policy, which discussed briefly just before, and I've just got one quote here from China's official Arctic policy. Again, China saying all the right things about how it will approach development in the Arctic. But one thing we need to bear in mind, if there is going to be an opening up of those sea routes through the Arctic in any large-scale way, with large vessels that are perhaps not so used to being in partly ice-covered waters, and if there's going to be a shipping incident, then how will the Arctic countries and China as a participant bring resources to bear to address any maritime casualties? Would be one of the concerns. But China has its policy, of course, in Chinese, and is articulating this as well in English, and it's saying, to my mind, all the right things. So let's see how important the polar is, the polar region is for China. So this map here is showing this area over here in Russia, where China has made significant investments to develop facilities for the export of LNG, liquid natural gas, to go to China. So one thing China's very interested in is securing the routes to China for the inflow of goods. So the development here in this area of Russia is to support the export from Russia of LNG to make it to China. We don't need to have the same level of concern for these type of activities under the BRI, because these would be investments in projects in other countries' territories. So that means what standards will be used? What is the governance framework that China has to make sure its projects that it's doing overseas meet its requirements, or otherwise meeting proper environmental standards of host countries? So one area I think that deserves attention is the governance structure for different projects that will be taking place. So whether it's all done under Chinese standards, or the different standards of the different countries, and how well is that being assessed. We also have an important problem of indirect expropriation. And this is a completely, as a field, I guess, completely different from law of the sea, but an established field under international law, where it's covering the situation where you would have investment from one country or from an entity in one country into another country, a host country for that investment. And if it's a situation where that money has come into the host country and that host country's government has just taken that investment, that would be called expropriation, taking the property away from somebody else. And that would, if that's done directly, that almost never happens these days, because international law is very clear. If it's been expropriated, that host country is liable to pay back the amount of the expropriation. But an area that's more murky is indirect expropriation. What happens if there's a foreign money coming into a host country to support a project, a large-scale, long-term project, but then over time, that host country has developed its laws and regulations, which has the effect, the indirect effect of devaluing the foreign investment. But perhaps an example could be if, say, China invests in another country to support the development of a coal-fired power station to support their energy supply. And that's something that takes a lot of money and a lot of time to build and get up and running. And then the host country later on develops regulations for environmental standards that are very strict, and there needs to be a whole lot of additional work done to make sure that coal-fired power station meets those standards. It could be to the point where it's not even viable to continue. So that would mean all the money that's come in for that project now has no value, or at least lesser value. So there is a key balance here between protecting the foreigner's investment, their right to the security over their financial investment, balancing that with the right of the host state to develop its laws and regulations as it sees fit for its own public interest. So environmental considerations, as all countries are, developing their environmental standards, is one area that could have an impact on the value of a foreign investment. And of course, we're talking China's BRI is a substantial amount of money, foreign investment in many countries. So the concern of those investments, what would happen if those host countries develop their environmental standards, is an issue that really needs to be looked at. And it gets dealt with under international law under bilateral trade, bilateral investment agreements. And those, and the clauses that deal with this type of issue of indirect expropriation can be wildly different across different countries. So the security of investment and making sure those investments, that the host countries can still develop their regulations without exposing themselves to liability is a key issue, I think. Looking at it, one of my last points, looking at shipping. Professor Lorenzo already mentioned a key aspect of the BRI will be increasing the scale of shipping. We have the issue I've mentioned before about port state control, the concern about the safety and environmental standards through the polar route. So this is going to be a key area for China to consider in how it's supporting the development of shipping. Professor Zou also mentioned, in the context of the South China Sea, seabed exploration. China is very advanced at the international level beyond the South China Sea in interest and expertise in the emerging area of deep seabed mineral exploration and subsequently exploitation. So this may be something where Chinese investments along the Maritime Silk Road, particularly I think through the South Pacific, may be something where it's trying to align with China's interest in the blocks it already has through the International Seabed Authority for exploration in deep seabed areas of the area under the law of the sea. And if we're thinking about China's all the different activities that China will be doing under the BRI, I think it's also important to bear in mind, if we think about fishing, China's track record on fishing. A couple of recent issues of concern are Chinese fishing, large scale and suspect fishing in North Korean waters, and an enormous fleet currently operating outside Ecuador's Galapagos Islands. So not necessarily breaching international law at all, but nonetheless it's a large scale, China has a large scale fleet. China has obligations to make sure it is managing that fleet and they're meeting all international standards. And I just want to finish on one good note about China's approach for international shipping with respect to MARPOL and air emission standards. That China has shown that it's actually leading in some areas in addressing the problem of commercial ships and their air emissions. So we know under the IMO there are some areas that are known as ECAs, emission control areas, where shipping can only take place if those ships meet higher standards than exist elsewhere in the world, such as having low sulfur fuel content. So some areas have been developed that only ships at that have the highest standards for the engines and other activities aboard their vessels that could have air emissions. Only those vessels can operate in these areas. But China has also been one of the very few countries that have gone down the path of designating areas within its own waters, not international waters, its own waters, where ships need to comply with its standards. So we've got up in the north, up in the east coast around Shanghai, and down in the south around Shenzhen, are three areas that China has already designated as areas where ships must comply with higher domestic standards. So this, I think, is a very promising sign. Information has been around for about a year or so, but it's pretty hard to get more detail on this, but something I'm looking into. So I think I might just finish off the final point. So coming back to the BRI and marine environmental protection, obviously one of the concerns would be the BRI is going to involve far more projects, far more activity, and they could come at a risk to the environment. So we're interested in making sure that any projects are going to be constructed in accordance with good environmental standards, and knowing that at some point, depending on if they're dealing with the marine environment, those standards are going to be under the law of the sea convention, and China must be following those standards as they've been amplified by the International Tribunal for the Law of the Sea. But otherwise, China needs to work well with the host countries to make sure that projects are constructed in accordance with their domestic laws, their environmental standards, and if those environmental standards are not the best, whether they can operate at an even higher standard led by China. Okay, so thank you. I might leave it there, and very happy to take questions.
Thank you very much, Warwick. It was very interesting the way you put the way in which you delivered the topic by trying to bridging a gap between the legal framework and what is actually going on the ground. By that, I think it was particularly useful. Let's see if there is any immediate question that needs to be taken, something which is related to your presentation and cannot wait for a full Q&A session. I don't see anybody raising their hands or using the chat, so I think we can move. Thank you very much, Warwick, and we can move to the next speaker. So it's now up to Chiara Tuo. Chiara is, as many in the audience will know, full professor of European Union law at the University of Genoa. She is also a graduate of the University of Genoa, and she has obtained her PhD in European Union law at the University of Trieste. Her research focuses on conflict of jurisdiction, transport law, as well as European Union law, with particular regard to the external relations of the European Union. In these areas, she has been the author. She's the author or co-author of many publications, including a leading textbook. Chiara is currently involved in a research project funded by the Italian Ministry of University on the One Belt, One Road initiative, for which she is a unit coordinator. Her topic today is the One Belt, the Belt and Road initiative in the prism of European Union law. Chiara, you have the floor, and welcome to the roundtable.
Thank you very much, Lorenzo. Let me first of all thank you as a Genoa colleague, but first of all a friend, for having invited me today to speak in such a prestigious roundtable alongside so authoritative and internationally renowned speakers, and also for having made me the proposal to organize, as you were saying, these events in cooperation with the research project that, as you were saying, has been recently financed by the Ministry of the University, and which is coordinated by Professor Zonarelli of the University of Bologna, and involves the University of Genoa, as well as other universities in Italy. This project, as you were mentioning, is focused indeed on the Belt and Road initiative, and therefore this occasion is really welcome to begin tackling this so interesting topic. The title of my presentation is, as you were anticipating, the Belt and Road initiative in the prism of EU law, and therefore I have thought of framing my presentation in the following manner. I first of all will address the issue of the current status of the EU-China relationship, and then will focus on 4 BRI-related questions, which, in my opinion, are most relevant from the perspective of European Union law. And then obviously I will conclude with some final remarks. Starting with the first point in my presentation, and therefore addressing the point of the current situation of the relationship between the European Union and China, with reference to the Belt and Road initiative. Well, we can essentially draw a distinction, a dividing line between 2 phases. The first one, which started around 2013, and therefore at the beginning, as the other speakers were, and you Lorenzo, were remembering at the beginning of the event of today, 2013 is the year with which it is commonly indicated at the beginning of this project, or this framework, if we want to name it in this way. This first phase began in 2013 and last 2 years, so until 2015. In this first period, the European Union takes a position which is not really active, and indeed it is the same China which is not really interacting with the European Union. The kind of approach chosen by China in this phase is to interact with single member state, and is in this sense, we can certainly mention the well-known Memorandum of Understanding, which has been entered into by China with individual member states, with the first one of these Memorandum of Understanding having been signed by Hungary in 2015. Why a kind of approach of this type? Well, essentially because on the one hand, maybe China wanted to take advantage of the situation in which some member states were following, as a consequence of the global financial crisis, a situation of sovereign debt crisis, where some cash-strapped governments were searching for finance sources to privatize infrastructures, and where this situation enabled China to enter advantageous deal. Indeed, this situation of financial crisis worsened the internal fragility of the European Union, the perception of lack of solidarity, of mutual trust, and made some of the member states enter in this Memorandum of Understanding, in this bilateral agreement with China. But we know also of a form of cooperation more extended between China and a number of member states together, which did not involve the European Union as a supranational entity. And my reference now is to the well-known 17+1 framework, which indeed involved a number, namely 12 member states, but not all of the EU member states. Obviously, the position within the European Union among member states is not uniform. We know of certain member states, such as, for example, Germany and France, which have expressed a dissenting opinion as regards the BRI itself, and more extensively as regards China, its economic policies, its scarce attention towards human rights. So it is a phase, this first one, which I am referring to, which sees a European Union which does not have a unitary approach, but rather keep a position of standby, waiting for the development of the project, even though recalling member states to their obligation to abide by the European Union law standard. Obviously, there are some concerns in Brussels in respect of China. First of all, the huge divide in terms of values, of ideologies, of political systems. There are concerns regarding public order, public security, and more related to the BRI itself, concerns that regards the opportunity to pursue some of the infrastructure projects which fall within the BRI umbrella. For example, within the European Union, someone questions are raised whether the project related to the BRI are economically viable solution, whether the fostering of the transport by rail, again, is an economically viable alternative to transport by air and sea. So there are concerns not only at the level of EU member states, but also at the level of EU itself. And such concerns pertain to China as a country, China as a political entity that sometimes make choices and take solutions which the European Union itself does not agree upon, but also concerns that regard the BRI project itself. However, as I was saying, the first phase, which lasts approximately between 2013 and 2015, has finished due to a more active and proactive, assertive, we may say, approach on the side of the European Union. Indeed, we can mention a number of initiatives that the European Union has taken, which evidence a change, a shift in the approach of the European Union towards the BRI. First of all, in 2011, we have the connectivity platform, which has been launched by the European Union and has been agreed upon with China on the basis of a memorandum of understanding signed previously signed in 2006, which is aimed to promote the European Union values in the relationship with China. So transparency, so reciprocity, so the establishment of a level playing field for businesses, and most of all, synergies between the two sides of the agreement. Because as we all know, the European Union has its own infrastructure project. First of all, one has to recall the Trans-European Transportation Network, which in 2017 the European Union decided to extend to its Eastern Europe partners, which is a choice which evidently may be in conflict, may at least overlap with the BRI project. So the connectivity platform of 2016, implemented more seriously from 2018, is a starting point for the promotion of these synergies between the two countries. Moreover, as evidence of the more active and assertive, as I was saying, approach of European Union, there is the critics that have been addressed by all of the EU member state ambassadors towards the BRI project, all the 26 EU member state ambassador, because the Hungary ambassador was did not take part to these critics, but such critics were indeed addressed to the BRI project by these ambassadors due to the lack of fair competition, which in their view affect the implementation of the BRI project, and that put the Chinese enterprises at an advantage. Third element that provide evidence of this new approach, of this shift in the policy of the European Union regarding the BRI, is the joint communication in 2018 of the Commission and of the High Representative, which is an alternative, an EU labeled program of connectivity between Europe and Asia, which is a kind of response of the European Union to the BRI project, in that it promotes connectivity between Europe and Asia, but in the European manner, in the European way. So again, on the basis of values that, in the eyes of the European Union, are lacking within the BRI project. So again, namely, transparency, reciprocity, national treatment, non-discrimination, fair competition, and fourth point that again indicate a shift in the policy of the European Union towards the BRI is another joint communication by the Commission and the High Representative, which is this time focused on China, and it is entitled EU-China A Strategic Outlook, whereby the European Union proposes a newly shaped approach toward the BRI, a multifaceted approach toward the BRI, because China is no longer qualified only as a strategic partner, but also as a negotiating partner, also as an economic competitor in the pursuit of technological leadership, and as a rival, also as a rival, a systemic rival, promoting alternative models of governance. This is the current framework of the relationship between European Union and China. Obviously, we know that there are negotiations which are ongoing between the two entities, between China and the European Union, for the signing of a comprehensive investment agreement. The negotiations have started in 2013. They are still ongoing, and the conclusion of such an agreement would certainly be of help in the implementation within the European legal order of the BRI projects. The European Union is certainly willing to remain engaged with China on the BRI, but as the European Union underlines in the last documents which I have previously mentioned, it now wants to act with a unified voice and towards by means of powerful, meaningful synergies. Now, passing to the second part of my presentation, and therefore addressing some of the EU legal questions related to the BRI, which in my view are more relevant. First of all, the question of the division of competencies between the European Union and the member states as regards the implementation of the BRI through the conclusion of international agreement. Second question that in my view is interesting to address is the issue of the applicability of the EU law on public procurement. The question, third, of the new screening mechanism of foreign investment which have been adopted by the European Union last year. Fourth, some brief consideration of the dispute settlement mechanism which is currently in place in China for the purpose of dispute which may arise in the process of implementation, the BRI project, but which have already been extensively criticized by the doctrine. So starting with the first issue, the first question, how can we consider competencies divided between the European Union and member states? Here we have to do a further distinction depending on the field which is concerned by the international agreement aimed at the implementation of the BRI. If, for example, we speak about common commercial policy, we all know that it is an area, it is a sector which falls squarely within the exclusive competence of the European Union. And we all know that the European Court of Justice tend to interpret extensively the scope of this common commercial policy in a manner that it encompasses not only issues such as the liberalization of trade or the abolition of trade barriers, but it also encompasses topics such as sustainable development, environment, labor rights, good government, and most of all, fair competition and procurement. Therefore, considering that the BRI project is mostly concerned with these areas, with these topics, with this sector of the common commercial policy, and namely market access, simplification of the investment procedures, custom clearance processes, or also the elimination of trade barriers, then we can easily conclude that to the extent that international agreements included in the BRI project concern these very matters, the European Union will certainly be provided with the exclusive competence to enter these agreements. Another area that, by the way, will be involved, will be interested by the implementation of the BRI is transport. Transport, as we all know, again, is not included in the common commercial policies, therefore is not an exclusive competence of the European Union, at least if we speak of international trade of transport services. But even in this case, we also know that there is the doctrine of preemption, and there is, most of all, Article 3.2 of the Treaty on the Functioning of the European Union, according to which the European Union has the exclusive competence to enter international agreement if such an agreement covers fields, covers areas which are liable to affect the uniform and consistent application of common rules, which the European Court of Justice has interpreted in the sense that not only one has to consider the common rules existing at the moment of the stipulation of the international agreement, but also their foreseeable development. Therefore, also on the basis of the well-known opinion 2002 of 2015 of the European Court of Justice relating to the Singapore Free Trade Agreement, we can also here easily conclude that to the extent that international agreement concluded or to be concluded within the BRI project are concerned with transport services in the rail sector, and also, at least to a certain extent, in the maritime sector, again, the European Union will be deemed to have exclusive external competence to enter this agreement. If there are part of this agreement which do not entirely fall within the external exclusive competence of the European Union, for example, in the field which is of interest today of maritime transport, to the extent that the provision of the international agreement do not only concern cross-border maritime service, then in that case, also member states will be allowed to enter the international agreement by means of the well-known mixed international agreement. In any case, it is difficult to expect that the European Union will not consider itself endowed with exclusive external competence, right in consideration of the ongoing negotiation, which I previously mentioned, of the EU-China Comprehensive Investment Agreement, also in consideration of the connectivity platform, which I likewise previously mentioned, which exists since 2016. And therefore, the initiative that member state would happen to take individually, unilaterally, not within, not through the European Union, shall be necessarily compatible and in line with their duty of sincere cooperation, which means that they will have to coordinate their action with the European Union in order not to endanger the European Union ongoing negotiation and to support the European Union in the conduct of these negotiations. The third area which is relevant when one speaks of division of competencies in relation to BRI is certainly direct investment. Direct investment has become field of exclusive competence of the European Union as part of common commercial policy since 2009, and therefore since the entry into force of the Lisbon Treaty. However, there are a large number of bilateral investment agreements between individual member states and China. The European Union will replace this bilateral investment agreement by means of the EU-China investment agreement. But in consideration of the lengthy of the process of negotiation, the question arises as whether the existing bilateral investment agreement of the single member states may cover the investments that the Chinese enterprises have undertaken and are undertaking in the European Union. In this regard, a distinction should be drawn between two main situations, two principal situations. The first one is that of investment agreement that have been entered by member state before their accession to the European Union, and the other one is the situation in which the investment agreement has been signed before the European Union has acquired the exclusive competence in the field of direct investment, but after the entrance in the European Union of the member state interested. The first situation, which is of the international agreement signed before the member state entered the European Union, as I was saying, is covered by Article 351 of the Treaty on the Functioning of the European Union, which essentially leaves member states free to maintain in place the international agreement, unless that agreement is liable to seriously affect principles that stand at the foundation of the European Union itself. With regard instead to the other situation, and namely of the international investment agreement entered by a member state after its entrance in the European Union, but before the European Union has acquired exclusive external competence, we have a regulation which has been adopted in 2012, regulation number 1219, which essentially enables member states to keep in place the international agreement, even to change, to amend it, or to enter a new agreement, unless the European Commission, which has to be notified of any of these changes in the international agreement, denies the authorization to proceed in such a way. And therefore, even though in a principle the investments which are currently taking place in the European Union could be deemed falling within this bilateral investment agreement, and member states are in principle free to renegotiate it or to amend it, the authorization is required by the European Commission, and it is foreseeable that such an authorization would be denied, would be withheld by the European Commission in consideration, again, once again, of the negotiation that the same European Union is conducting with China for an EU-China comprehensive investment agreement. Passing now to the second question of EU law, which in my opinion is of some interest, speaking about of BRI, and namely of the EU mechanism for the screening, for the monitoring of foreign direct investment in member states. We have immediately to mention the new regulation, which I previously named, the regulation 2019 number 452. This regulation does not provide an obligation for member states to introduce a screening mechanism for foreign investment. It simply, if one can say simply, it simply introduces a framework to report on foreign direct investment, which means that member states are required to notify the other member state and the Commission of their screening of foreign direct investment. The Commission has an advisory power, which means that it can be required, it has the power to release an opinion when it is where there is a situation in which one fourth of the member states is of the opinion that a foreign investment is liable to endanger national security or public policy, or when the foreign investment is likely to affect the security and public order in the European Union. The regulation also provides a list of it provides a list of the grounds, but a non-exhaustive list of the grounds which may trigger a refusal of the foreign investment for reason of national security, public policy, such as the investment in the infrastructure sector. No doubt that this regulation will be of relevance for the purpose of the implementation of the BRI project, not only because the project entails direct investment from China, but also because this project is mostly concerned with critical and crucial infrastructure in the member state. In addition, we have also always to remember that, as I was previously mentioning, the implementation of the BRI project is liable to overlap, to conflict with EU programs on infrastructure. First of all, the Trans-European Transportation Network. Certainly, it is not a mechanism of screening, of monitoring foreign investment, which is particularly developed, particularly advanced and extensive, considering that the China itself has a more advanced system for the monitoring of foreign investment. But it is nonetheless a first step towards further developments that we have certainly to expect in this very field, and that will probably lead to the adoption of a unified framework procedure for the monitoring, for the screening of foreign investment in member states. Today, as I was saying, not all member states have their own screening mechanism. The screening mechanism that have been adopted by some of the member states differ one from the other, so much so that someone has spoken of a patchwork of screening mechanism existing among member states. So the way forward is probably that we will arrive to a unified approach, and then to a pooling at the EU level of the security assessment and the decision-making authority. However, it is to be welcome, and it is to be considered a first important step that the Commission has a first role, a role that is advisory, as I was saying, but however means that the Commission is involved in the control, in the process of screening foreign direct investment. Then there is the third question, which I would like to briefly address as relevant in the prism of EU law when one speaks of BRI, namely the application of EU law on public procurement. We all know that, and we have also here today, that the BRI is to be implemented, has as its goals, objectives, the construction of infrastructures, and these infrastructures are mostly financed, backed up by Chinese loan. One example for all may be, speaking of European Union, the Budapest-Belgrade railways, which was approved at the end of 2014. We know that the Hungarian limb of that railway came under the investigation of the European Commission because of the alleged infringement of the EU law rules on public procurement, so that Hungary had to open a tender, a public tender, in order to award the works, the construction works, which were in the end awarded to a consortium between Hungarian and Chinese enterprises. The point is, in this field, in this sector of public procurement, that the rules existing in the EU legal order are provided in 3 directives, and one could ask whether these directives are indeed applicable when it comes to projects of the BRI. The directive provides for some exceptions to their application, exception which essentially applies when either the public procurement rules are agreed are set forth by international agreement or by an international organization, or where the public procurement rule, in addition to being established by an international organization, pertains to works, to contracts which are to be financed by an international organization or institution. Am I going out of time, Lorenzo?
I think you should approach the conclusion, more or less, if this is, sorry for rushing.
Thank you very much. The conclusion with regards to the public procurement is simply that the BRI project do not fall within neither of the two exceptions which I mentioned, for the simple reason that we are not in presence of any kind of international organization. The 70+1 framework, which was involved in the Budapest-Belgrade railways, cannot be considered as an international organization. Chinese banks, which are financing institutions, cannot be considered as international financing institutions. Therefore, public procurement law are in principle fully applicable to the project, to the infrastructure project, which are to be carried out in the context of the BRI. To conclude, we have assisted to a shift, as I said previously, in the policy, in the approach of the European Union towards the BRI. The intention, the program is to speak, as I was saying, with a unified voice, and to proceed, to move on in the negotiation of the Comprehensive Investment Agreement, and more in general in the implementation of the BRI in terms of meaningful synergies with the EU own connectivity initiatives. However, the 2020, the year 2020, which was expected to be a turning point in the relationship between the European Union and China, as we all know, has shown scenarios which were completely and totally unexpected and unimaginable. The opinion of some author is that the BRI is to take a back seat, waiting for the situation to become more clear. A fact is that the news is of these days that the Ministry for Foreign Affairs from China has started a tour in Europe, and the first country he visited was indeed Italy. The objective, the intention behind this tour is clearly to reactivate the contact with the European Union, also in consideration probably of the development of the relationship with the USA. We cannot but wait and see if this development will be in the near future, or as someone expects, we have to wait longer for them. Thank you for the attention, and sorry if I have taken more time than I was assigned.
Thank you very much, Chiara. That was an excellent presentation, which pointed at the importance, the importance of verifying or analyzing the peculiarities of the European legal order as a terminal of the One Belt, One Road initiative, as a Western terminal of the One Belt, One Road initiative. I will ask whether there are immediate questions to be taken for Professor Tuo. If there are none, we are not late, but we started having plenty of time and we have just the right amount of time. So if there are no immediate questions, I will move to our next and last but not least speaker, Professor Fabrizio Marrella. Welcome to this roundtable. Thank you for being here. Fabrizio is a full professor of international law at the University of Venice, Ca' Foscari. We invited him also to show that peace and cooperation between the two ancient maritime republics is a fact nowadays. He has obtained PhD titles from the universities of Paris and Bologna. He has a very rich curriculum. He is a very prolific author, and his research focuses in particular on international trade law, investment law, international contract law, and international dispute settlement, including arbitration. He has recently published a textbook on international trade law, and he's in addition the director of the Master on Strategic Studies and International Security in partnership with the Italian Navy. He will be speaking about a very interesting and topical issue, which is the Belt and Road Initiative and international trade law, with a focus on Incoterms 2020. Fabrizio, it is my pleasure to give you the floor.
Well, thank you very much, Lorenzo. Before I start, let me thank you sincerely for this fantastic invitation, as well as all distinguished colleagues from Genova. You're right, after perhaps 1,000 years, we are working together particularly well, and we are in the same, I would say, line of thinking on many things. And in particular, let me also thank the speakers who have spoken before me. And also, I've seen Professor Carbone, who's among the participants. I'm particularly honored to be here. Now, before I start, let me also say that the speaker before me have very well analyzed the scenario. Professor Keyuan Zou has said that more cooperation will certainly bring more maritime traffic, which is certainly useful for my presentation. Professor Gullett spoke also that said that the transport by seas is the most efficient, and it's true. Almost 90%, as we know, of international trade requires transport by sea. And Professor Tuo has illustrated very well the European Union position. So my presentation actually is the chance to move from the macroeconomic and macro legal level scenario in strategic terms to the micro level. And I have prepared a PowerPoint, which should be, let me see, I should be able to show. I don't know if you can see that. Can you see that?
Yes.
Okay, thank you. Well, I can skip the first two slides because that was the definition of BRI, which has been illustrated. And by the way, the picture that has been used by the other colleagues has been much better than this one. And let me just then go to my point. Trade, as you know, is made operational through international contracts, and this facilitation of trade, which is the BRI project, requires at the bottom line a better, let's say, fine-tuning of all import-export operations. But as we know, the bottom line of any import-export operation is the contract for the international sale of goods, which is coupled with the contract of carriage, which is also coupled with payment mechanisms and dispute resolution mechanisms. So any contract, and in particular between Italian or European operators and Chinese operators, present two basic questions. which are the classical questions in international private law or international business law. Who decides the case is the first one. And here comes the first good news. Chinese culture, as many comparative lawyers have shown many times. I am grateful to one of them in particular, Professor Crespi Regizzi, who's been working so much on that, shows that China and Asian countries have a specific culture of arbitration, mediation, negotiation. So arbitration is not a problem in case of litigation. And in fact, China is a 1958 New York Convention country on the recognition and enforcement of foreign arbitral awards, even if there are still reservations of reciprocity and commercial law. The second issue concerning the applicable law concerns, of course, the CISG, and the CISG also gives good news in the sense that China is a contracting state, as Italy. The new China Civil Code, which has been enacted a few weeks ago, and I'm speaking, of course, under the control of Professor Keyuan Zou, it will take effect on January 1st, 2021, but there are no derogations, neither from the CAG, obviously, nor from Incoterms, which is the topic which I am here to speak about. So what is then the role of Incoterms? Now, some of you perhaps are already familiar with this issue, but for those who are not familiar with this issue, let me say that these are a product of the International Chamber of Commerce, which is an NGO, say the most important non-governmental organization, so important for international business law and trade. And one of the first works of the ICC was precisely that of codifying in 1936 the most, let's say, standardized operations that any international sale of goods involve. To make an easy joke, I would say that those who specialize in the CAG, well, still do not understand international sales until they don't get into the Incoterms, because Incoterms are complementary to the CAG and make it operational, as you will see in a moment. More generally speaking, Incoterms are a product of transnational, non-national law or lex mercatoria, with all the things that involves. But we'll see that we don't need to discuss that issue to see Incoterms in action, since we can simply assume, for the purposes of my presentation, that they are standard clauses which are standardized by the most important NGO in international trade. They clarify obligations that each party has with regard to freight costs, risks, and insurance, and they may be recognized as trade usages for the purposes of Article 9 of the Vienna Convention on the International Sale of Goods. And most importantly, they exist in different sets. In other words, the International Chamber of Commerce plays the role of codification of these clauses, and every 10 years or so, there's a new set of rules which are the reference point for anybody doing international contracts, in particular international sales. So the next question will be, all right, now is there any specific issue that concerns China in this framework? Well, you know, Chinese experts are frequently participating to the work of the ICC, and according to my information, there is no doubt that Chinese business doing international sales will apply the Incoterms. Speaking differently, it's interesting that in the years before 2020, when the revision of Incoterms was on, in every national committee in Italy, France, Germany, the United States, and all over the world was working on the proposals for the revisions of the Incoterms in the famous CLP Commission, which is the Commercial Law and Practice Commission, where I'm honored also to serve in Italy. Well, there was no specific proposal for, let's say, a Chinese Incoterm which would fit better the Chinese interest. This means that Chinese businesses work very well with Incoterms, and at least in international business, which could be different from domestic practices, but this is not the purpose of our conversation. What is the recognition of Incoterms? Well, first of all, for those who were, let's say, especially in academia, opposing lex mercatoria and all products coming from the private sector as transnational business, well, I think that debate today is quite sober, in the sense that UNCITRAL, the United Nations Commission on International Trade Law, in 2005 approved and recommended Incoterms for international business contracts. And in particular, the European Court of Justice, in the famous Electrosteel case in 2011, recognized that usages may be collected, of course, by professional organizations, but in particular, the Incoterms are an important, actually a fundamental reference point, even for EU law purposes, as far as they define and codify certain terms and clauses commonly used and widely applied. Now, of course, this is the position of an organization, an agency, the position of a court, the position of international commercial arbitrators, which have been dealing with international sales and Incoterms. We have to remind to our colleagues doing private international law that according to statistics, 80% of international contract does not go for a litigation before a national court. So international commercial arbitrators, being experts of the field, have not had any problem to recognize those as international standards, if not trade usages, for the purposes of the Vienna Convention on International Sale of Goods. So the questions that Incoterms resolve, as some of you may know, are three, basically. Who bears the risk when goods are damaged during transport? What costs are paid by the seller and by the buyer? And who does what to make the international sale happen? I said that if we are the top expert in the world of the CIG, we are certainly great expert, but still we don't know and we don't really understand how an international sale happens until we get into the Incoterms, because the Incoterms tell you exactly who is in charge of the main carriage, who has to deal with customs, which is another set of important issue, and who is eventually obliged to contract insurance to cover against the buyer risk. In 2020, as I said, there has been a revision of the Incoterms by the ICC. Now, for those of you who are already familiar with the Incoterms and are scared about the changes that since 2010 we find in the 2020 revision, I can give you good news. It's basically maquillage, as they would say in Paris, but certainly good maquillage, in the sense that there are no dramatic changes vis-à-vis the 2010 rules, which were working fairly well. So basically the 2020 revision is useful because they have been, the working commission, the CLP commission has simplified and updated a little bit the rules, have distinguished the levels of insurance in the CIF and CAP Incoterm. I will go back to that in a second. It has been possible to include some reference to security related requirements in certain Incoterms that you see at point 4. There have been clarification in case the seller or the buyer decides to use the wrong means of transport, because logistics, as you can imagine, it plays a very important role. And even if there's been an intense debate concerning the issue of eliminating the famous Incoterm Ex Works, on which I will come back in a second, and introducing instead considerations concerning VGM, which is basically the recommendations and requirements imposed by SOLAS, the International Convention for the Safety of Life at Sea, which contains important rules for the weight of containers, just to give you an example. Well, all this debate has not really produced anything in this revision. So Ex Works still is there, even if, as we will see, is not the best Incoterm for international sales, and SOLAS is treated outside the Incoterms. That's basically it. The full picture is here. We have 11 Incoterms They are identified with an R as the registered trademark and 2020, just to identify the version. Let me just remember that the content of these three-letter rules is defined directly by the International Chamber of Commerce in an official publication, and therefore it may change, and it has changed, by the way, from version to version. So today, in order to be clear and precise, we must indicate Incoterms 2020. Now, this picture sounds a little bit dense and almost confusing, but you can look at Incoterms by dividing them into the famous 4 categories that explain very well the position of the parties, starting from the seller position, which is the E category, and reaching the buyer, which is the other extreme of the supply chain, which is the DDP, delivered duty paid. So we have only one Incoterm in category E. Those 3 Incoterms in category F, which is characterized by the fact that the main carriage is unpaid, meaning that the seller normally takes care of everything until his own port, meaning the port in his own country. So if you are in Italy, it will be the port of Genova or Trieste or Venice. And category C, as we will see, instead adds on other costs concerning the main carriage, which is offered. I like to use this expression offered because as you can see, the change from a category F to a category C is another strategic choice of a business in doing import-export, because that means that you're gonna bring the goods until the port of your, let's say, Chinese buyer, and there will be cost, specific cost concerning that. And the final category, which is the, let's say, the best possible world for the buyer, is category D. Well, the seller takes care of everything and the buyer simply needs to pick up the goods in his own country. You will see more in a second. Most importantly, and I would like to highlight this because in even some textbooks, you have the impression that the Incoterms are only 3 lines that explain each single 3-letter words. Well, if you want to know exactly all the obligations of the parties for each Incoterm, you need to consult the official publication of the International Chamber of Commerce, where you will see in details all these chapters concerning every single Incoterm. So you will see general obligation, delivery, transfer risk, who does carriage, who does the insurance, and so on. So I will just give you an overview, but if you want to know details, you will have to consult that. Ex works, well, for those who are familiar with that, has not changed since Incoterm 2010. As I said, it is the easiest for the seller because the seller delivers, and when I say delivers, I mean it for the purpose of the CISG, the Vienna Convention on International Sale of Goods. Main obligation of the seller, as you know, is the delivery of the goods and the documents. And delivery here happens at the premises of the seller. So the costs, as you can see, are transferred when the goods are placed in front actually of the door, as we say, of the warehouse. The seller doesn't have to load it into the truck, and you may find sometimes a little bit exaggerated all these details. Oh, should it load it? Why shouldn't he load it into the truck if this truck is, you know, coming from perhaps a different country and needs some help for loading? Well, if you look at case law about Incoterms, you will find that most of litigations happen because things broke during loading or unloading operations. So, you know, the fact that the Incoterm says the seller delivers when the merchandise, when the things are placed in front of the warehouse, unloaded, has a specific meaning, and it builds on the practice of almost 1 century, as we can see. And of course, if the seller performs here, well, the buyer has to organize the logistic chains up to his premises, let's say in Shanghai, China, if you're selling to a Chinese firm. Now, this Incoterm is the preferred one by the Italian business, many Italian business, small and medium businesses, but has some problems. And these problems are well known. The problems are that if you are exporting, the exporter may find himself in the position of not having proof of actual export, because if you are just, placing the goods in front of your warehouse, well, especially in the past where the paperwork in the customs was done, was really paper, it was very difficult for certain exporters to prove the actual export of goods for customs purposes, and in particular for VAT, value added tax purposes. So we continue to repeat even today that Incoterms are useful for, let's say, intra-European or domestic trade, but should not be used for international trade. It's interesting to see that also in China, there's a similar view on ex-works. So you may find many let's say, local businesses that would opt for an ex-works, but with that specific problems. Another important Incoterm, it's FCA. And as you can see, with the two variants, which are not so different from the 2010 variations, and in the first formula, which is FCA1, the delivery of the goods happens in the seller premises when they are loaded on the transportation vehicle arranged by the buyer. So here there's a loading obligation on the seller. And there's also a variation, FCA2, in which instead the point of delivery is elsewhere, is not in the seller premises, but is in a different point, for example, a warehouse, which is different from the seller's warehouse. And in this case, of course, the Incoterms is very detailed in saying that the goods are deemed to be delivered when, of course, they have reached the named place and are ready for unloading from the seller's transportation vehicle. So here, the vehicle of the seller waits for the delivery to the first carrier sent by the buyer. Interestingly enough, FCA here has been changed because of practical issues arising from let's say, bill of lading and letter of credit operations, in the sense that with the new version, so if you agree on FCA 2020, you will have the seller who will be obliged to send you, the buyer who's organizing the main transport up to his own premises, who will have to deliver a bill of lading with an on-board notation to the seller in order to make the letter of credit operation work. That's very important, because if you are the seller in an FCA classical operation and you don't deal with the main carriage by sea, well, you lose the possibility to get a bill of lading with an on-board notation, right? So with FCA, this has been the recommendation, which has been, we'll see how it works, but it should be certainly better than the first one. Now, FOB, and Lorenzo will tell me if I run out of time. Of course, I'm not getting all the 11 Incoterms analyzed, but I will just provide you information on the main ones. And FOB certainly is one of the main ones, but FOB, if I may say so, doesn't change from the 2010 version. So here, the delivery point, as you can see, is on board of the ship, but this ship and the main carriage operation is organized by the buyer. So if the seller delivers goods on the ship, well, the delivery has happened and therefore is entitled to payment. Well, in the 2010 revision, that was an issue because the delivery point was different. But in the 2020, the 2010 solution has been retained. So as you can see, the costs and the risks run in parallel, which is not what happens with the C terms. As I said, with the C terms, the strategy of the import-export business becomes different. Here, the marketing people would say, you try to offer an extra service to your customer. So instead of being like, you know, the lazy seller who sell X words and wait for the clients to come to his own office in, let's say, Venice or Genoa, with the C term, which is CFR, CAF, we will see the variations, you try to push the goods forward and make it arrive up to the port of your customer. You get your goods closer to the customer. But there's a variation here. And in fact, in the CFR, you will see that the point of costs, as you can see, runs to the port of arrival. The cost line arrives to the arrival port. The risks line instead is like in the FOB. So when you have C terms, you have this famous double critical point. Double critical point means that there's a critical point for the passage of costs and a critical point for the passage of risks. Of course, you are mostly interested to the passage of risks. So if you are the seller and you're selling CFR, it is true that you will bring, or you pay actually the logistics up to the point of arrival of your buyer. But the risks will be transferred as in the FOB, which means that when the goods are on board in the port of departure, which may be important because if between the port of departure, let's say Trieste or Genoa, and the port of arrival, let's say Shenzhen in China, you have a piracy attack, it was mentioned before, well, you have a problem of who bears the risks. And if you have agreed on the CFR or on a C term in general, you will see that the risks have passed in the port of departure. So a piracy attack en route, as we say, will not be an excuse for the buyer not to pay. The variations of the C terms are the CIP and the CIF. Here, as I said, there have been some variations in the Incoterms 2020. The structure of the Incoterm is as before, meaning the cost line reaches the point, let's say, of arrival, but the risk line arrives on the point of departure. The difference is that here the seller has to pay for an insurance on the goods, and the Incoterms 2020 also say that this insurance should be according to the famous all risks clauses of the Institute Cargo Clauses, which is in London, meaning that the maximum coverage, but keep in mind that even if you have an all risks coverage, but that doesn't cover, paradoxically, many risks. For example, risks of war. If we have a war in the South China Sea and you are under a CAP carriage, an insurance paid to Shenzhen, well, that doesn't save you from war risk. If you want war risks, you have to pay for an extra insurance. But as you can see, the Incoterms will say that the seller has to pay a clauses, Institute Cargo Clauses insurance, which is very wide. It's called all risks. But if you look into the details, you will see that war risks or piracy, war risks, piracy is included, but war risks are not included. So in this case, the seller and the buyer will have to negotiate for a specific coverage with sometimes a different insurer. The CIF, as I said, is more or less basically like the one that we used to know in the Incoterms 2010, but the difference is that the insurance, and the line of insurance is always the same, is connected to a different level of coverage. Here, the Institute clauses, which are used, the Institute cargo clauses, are the clauses called C, which is basically a minimum coverage. So makes a difference if you are exporting or importing with a CIP or a CIF, because as you can see, the level of insurance is different. And that's one of the changes that Incoterms 2020 have produced. The D terms, as I said, reconnect the cost line with the risk line. So the bottom line here is that the seller is very generous, very marketing oriented, and brings the goods into the country of the buyer. So more expensive for the seller, definitely. More risky, yes, it is. More comfortable for the buyer, it is. And you have some variations, deliver a place unloaded, or the famous DDP delivered duty paid. On that, which is sometimes preferred by, let's say, Italian buyers, for example, because they can sit comfortably in their armchair and wait for the goods to arrive, we have to remember let's say, a downsize of this specific Incoterm. Downsize is that it is true that the exporter, let's say the Chinese exporter, will pay all the costs and will have to deal with all the documents, risks, including customs formalities, including in the country of import. The problem is that, and I have actually tested that a number of times, having had the pleasure to edit a commentary on the European Union customs code. Well, for the custom agents, this kind of Incoterm is not really interesting. For the custom agency, obviously, what matters is who is the importer. So if you're buying DDP and you're sitting comfortably in your armchair and you're waiting for the goods before your door, as you do with Amazon, by the way, well, keep in mind that in case of false declarations or problems with the customs authorities, you will still be liable, because one thing is the contract of sales and another things are the EU customs obligations, which are public law obligations, which are not derogable. All right, so I had also prepared an example, but I'm running out of time, and I've introduced examples in my presentation. So if you allow me, I will say a few words to conclude. And the few words to conclude are that Incoterms are extremely useful in such a complex scenario because they deal with risks. And as you have seen, they are also dealing with risks of war, not only of piracy and so on. They deal with costs of the operation. They deal with ancillary operations concerning carriage, concerning insurance, concerning custom clearance, even if they are private law exercises which cannot certainly derogate public law mandatory rules. And therefore, all in all, there is no doubt that Incoterms will keep us busy in the BRI project as international lawyers for the years to come. This is the challenge of the complex scenario, which has been described today so well also by my colleagues. Thank you very much for your attention, and I leave the floor to Lorenzo.
Thank you very much, Fabrizio, also for your excellent timekeeping, and also for contributing with from a perspective which I think it is often underestimated, that is the perspective of private operators, because it's always good to talk about large-scale scenarios. It is always good to speak about general principles of law, but the system works if at the end of the day we have a clear legal framework which is somehow ready to be used by private operators. Of course, that does not mean that controversies and disputes will not arise. These are always on the agenda, but to be able to speak according to a common set of rules, also in this when such a long voyage is concerned, is always very useful. So thanks a lot. So now we have some time for questions. I hope that there will be questions from the from those assisting. Okay, so I will go according to the order in which the hands are raised. I see the hand of Ralph Matney, who is a participant to the summer school from Lebanon. Ralph, you may activate your camera and your mic, and please try to be synthetic when you are posing your question, so there is time for others to speak as well. Thank you.
Okay. First of all, thank you very much for all the speakers. I have actually two small questions, one for Mr. Marrella and one for all the speakers. I wanted to ask if the contracting parties have contradictory clauses in their contract. One that has the Incoterms in it, and then another contradicting clause with it. How such contracts are handled either by the arbitration or any dispute resolution manner? Does the Incoterm have like, is it usually does it have I forgot the word. Is it dominant over other clauses because, well, it's in the treaties? And another question for the speakers, starting with like all the four speakers. I wanted to ask if there's any international treaties or any legislations other than the local legislation, considering the I'm sorry, the Belt and Road Initiative. Is there any legislations other than the local states on fighting either corruption or the transport of illegal material? And what's either the Chinese legislations or contracting parties legislations about the arm transport? Is there anything specific about these matters? And thank you very much.
If all speakers agree, I would take a bunch of questions and then give the floor to you in turn, so that we do not do too much back and forth with questions and answers. Also because some questions may be related and to each other, and so be answered comprehensively. So we took note of your question to Professor Marrella and to the more general questions to the others. We now, I see that there is a question from Chang Ye. Do you want to address that directly? I see it in the chat, but perhaps you want to show yourself.
Oh, yes, thank you.
Yes, he's a summer school participant, PhD student in the UK, but from China originally. Please take the floor.
Oh, yes, thank you. A small question goes to Chiara. As we know, Italy is the first big European economy to join the BRI project. Well, several Western European states, including France and Germany, still refuse to officially participate in this project for probably being concerned about China's influence. So do you think the different policies over BRI among the EU members could split the EU? Thank you.
Okay, is there anybody else at this stage willing to raise a question or make a comment? I don't see anybody, so maybe we turn to the speakers and, well, yes, there is someone. Jordan, yes, why don't you activate your mic and camera? Jordan is from the UK, is a law graduate and also a participant to the summer school. We can see you. Now we see you. Go ahead. Go ahead, Jordan. Your mic is not. No. So maybe you want to write your questions? Okay. And I will read it out. No pressure on you. Perhaps in the meantime, Fabrizio, do you want to, we can go the other way around from the last to the first now.
Okay, well, I think that the first question concerning contradiction or conflict between Incoterms and other clauses of the contract is a wonderful one. And let me articulate my answer with three scenarios at least. But first of all, you may have a situation in which an Incoterms selected but agreed by the party is in contradiction with another clause of the contract. Well, could happen. I mean, if you have good negotiators, this shouldn't happen, but it could happen. But this raises a problem of contract interpretation, which is not regulated by Incoterms, but rather by the applicable law to contractual obligations. This also doesn't mean that an Incoterm cannot be changed by the party. If you're unhappy, for example, with X works because you have to place the goods in front of a warehouse unloaded and you want to have an X works loaded, you can do it. But certainly the International Chamber of Commerce recommends not to change the meaning of the Incoterms, because instead of uniformity, which is the purpose of the exercise, you get further, let's say, contractual interpretation issues. A second scenario would be when the Incoterms are different from the 1980 Vienna Convention for the International Sale of Goods. Can this happen? Certainly yes. And in fact, if you look at the CSG analytically, you will see that, for example, all articles 66 to 70 of the CSG, which deal with the transfer of risks, are derogated by the Incoterms. But here the question, I would say, becomes the following. The question has to be taken from the side of the CSG. Is the CSG a mandatory international regulation, or can it be, let's say, changed by the parties? As you know, Article 6 of the CSG allows the parties to derogate from the CSG, which is not what happens with the famous international conventions on transport, or maritime transport. You take the Hague-Visby rules and all these things, and you know that transport conventions are mandatory in its nature. Now, the CSG is not, and therefore a conflict between an Incoterm and CSG can be resolved in favor of the Incoterm, which is the real will of the party. The third situation could be a conflict between a specific Incoterm clause, let's say FOB, and a rule of the applicable law to the contract, which is the object of a separate clause, right? So let's imagine that the applicable law to an international contract is Italian law and the CSG is not applicable. You have a conflict between an FOB clause and, let's say, the Italian civil code solution to the same issue. Once again, the question has to be resolved under the light of the applicable law, and the answer is, well, is that specific rule of national law mandatory? I would say overriding and mandatory, or is it rather a disposable rule, as we say? But you will see that most of contract law rules in the world, and I suppose also in the new Chinese civil code, are dispositive, they're not mandatory. So the parties can derogate from them specifically on what concerns the point of delivery and the risks. So as you can see, in practice, these conflicts do not really happen or can be handled in an efficient way. So that's my answer.
Thank you very much.
Do you also want to say something about the more general question that was asked to everybody, or this is a little bit out of the topic that you presented?
I've spoken too much.
Okay. Okay, so now we go to Chiara. Chiara has also a specific question to her from Chang, and more general questions too.
Yes, thank you, Lorenzo. Yes, the question was whether, in my opinion, the fragmented approach followed by the by China in view of implementing the BRI is liable to create a division among member states, and obviously the risk is that one, is indeed that one. The approach followed by the European Union, however, as I said, was initially that of waiting for development of the project. The shift, however, that we have registered starting from 2016 is in the sense of a more and more unified and coherent approach of the European Union towards the BRI, and this program, this intention, has been manifested by the European Union in several of its official communication, either pertaining strictly to the BRI, but also in those other communications, such as the one on the connectivity between Europe and Asia, which are not strictly relating to the BRI. So the European Union is well aware that individual and bilateral relationship between China and member states is at risk of endangering the cohesion and the unity of the European Union, and also for this reason is repeatedly stressing the importance that the relationship be between China and the European Union speaking with a sole voice, a unified voice. I don't know if I have answered.
Thank you very much.
You're welcome.
And so we go to Warwick. I think you were asked to say something also on the more general question that was asked by Ralph.
Yes, thank you, Lorenzo. Yes, so Ralph's question was asking, is there anything in the agreements, as I understand it, the agreements with the BRI, with China and other countries that are dealing with the issues of arms transport or corruption or the transfer of illegal material. I don't know about arms transport. I think it's very difficult to work that out, because the agreements that are public tend to be those in the form of an MOU that's very sort of general and pleasant sounding, or otherwise maybe a framework agreement, rather than very hard-hitting and technical. It might be hard to find those in all the individual countries. So one that I've looked at is the only one we have here in Australia, which I mentioned before, is by the government of Victoria, the state or province in the southern part of Australia. That was signed as an MOU in 2017. without any consultation with the Australian federal government or the Department of Foreign Affairs, which upset the federal government. There was a secondary agreement. So the MOU was signed in 2017, and then a framework agreement sort of to implement that was signed in late 2019. But that has some general clauses. This is actually public, talking about transparency and openness and good governance, but nothing more than nice sounding phrases like that. So I think if there's going to be anything very specific with a word like corruption, that might be in a document, if it does exist, a document that wouldn't be made public. And it's also worth looking at the approach China would have taken to negotiate these agreements in all the different countries, and in the case of Australia, with actually a subnational government. So the wording of them may differ, even though they're all with China, but the other countries vary. And if they're going to be in the form of just general agreements to cooperate, well, you might have some pleasant sounding terms in there that head in the right direction, but there would be no real substance, I guess, for that agreement. Anything like that would be a more technical contractual arrangement for specific money flow. Thanks.
Thank you, Warwick. I'm not sure whether Keyuan wants to add anything to this. There is also a question addressed in particular to you, because Jordan, who could not make his mic working, is asking, it was mentioned that recap contributes to the legal definition of piracy. What is the current definition and how does recap contribute to it? I think you were...
Thank you. Okay, thank you for your questions. I just corrected some question off and asked about whether there are some laws and regulations about the corruption at a domestic level, and in China, and actually there are a lot of laws and regulations governing corruption and official corruption, corruption in business and other sectors, and but the Chinese system is very special, and if you are a Communist Party member, and first of all you are subjected to the party disciplines. So when party official and is suspected to be corrupted, then first he will be brought to be investigated by the disciplinary department before he faces or she faces the justice. So that is the very different. The second point is China also used the Interpol and to bring back the escaped corrupted officials from overseas. So we can see that this happens from time to time in the mass media, and so this is a kind of corruption. The second is about the definition, and the definition, if you look at the definition, the traditional definition, which is contained about the policies, which is contained in the law of the convention, actually it first appeared in the 1958 Convention on the High Seas. So that is very old and traditional, and that it contains several elements. That first is for private purposes, and the vessel-to-vessel requirement, two vessels requirement, and also it must happen. The policy must happen on the high seas and or the places beyond the national jurisdiction. But the law of the sea changed, and the maritime zone maritime zone of national jurisdiction extended greatly from the coasts, so that the traditional definition definitely can't effectively deal with the policy issue globally. So that is why in the 90s led latentes, and the IMO suggests a definition that include the armed robbery against the ships. So now the definition is piracy and armed robbery against the ships. That is the definition. But shortened it, of course, the armed robbery is a part of the piracy, and they are treated in practice the same in practice. So that this is the definition. So the recap definition is the piracy and armed robbery against ships. That is the definition. And also the difference is in the law of the convention, it includes aircraft, but in the recap, aircraft is dropped, and also the high seas requirement dropped. So it is a kind of development, and all this consistent with the UN Security Council resolutions and IMO guidelines. So but the difference is whether UN resolution or IMO guidelines, they are political documents, and the treaty recap is a legal document. So that is why it changed the definition of the traditional definition embodied in the UN Convention on the Law of the Sea. So that is the kind of significant development. And the third one is about Gilia and asked the pandemic about the BRI.
You're very good. You can see
that is a very interesting question, you know. And because to me, I'm a bit pessimistic about the development of the BRI because of the pandemic and the economic slowdown globally, and even now, and China faces a lot of economic problems internally, and whether China can invest further on these projects, I doubt it. And and also the international environment is not that favorable for the BRI implementation, because many countries, particularly the United States, they have the suspicion that the BRI could expand the Chinese so-called Chinese hegemony or Chinese control over the world. So such kind of political security concerns, and also hamper the BRI implementation. So the BRI actually, after the pandemic, will face its crisis. I don't know whether it will be viable and can be implemented smoothly. This is we can just wait and see. Thank you.
Do any of the other speakers want to say one or two words about this aspect, whether COVID-19 is going to impact heavily on this project, or are you happy with the wise words of our Chinese speaker? Please, Warwick, or please, Warwick, you can speak first, and then Fabrizio.
Both Lorenzo, I'm very pleased with the wise words of Professor Zou. Yes, there would be concern about the viability of funding from China to continue to support the BRI at the same rate, with the hit to the economy in China, among other places in the world, and whether the banks in China will have the liquidity to be able to provide the funding as expected. Also, another aspect for the slowdown of the BRI projects is simply the difficulty of moving from one country to another. Even though some of this would have been happening with shipping, but we know it's very difficult to travel. Actually, in Australia, we are not allowed to leave the country. Australia is very strict. So simply the impact on the movement of people will have an impact on these development projects. And I think just one other point briefly is that all the contracts arranged for all the different projects the wording of them will need to be very scrutinised very carefully if there's allegations that one party hasn't been able to fulfil its obligations, and whether they can, under the contract, classify COVID-19 as a force majeure, as an act of God, you know, that means they are relieved of their obligations under the contract because the whole nature of COVID-19 could not have been anticipated. There still may be a due diligence requirement to make sure that they minimise their non-performance and they acted well, but really that will come down to exactly how a force majeure clause, if it's included in one of these contracts, which is quite common, exactly how it's worded, and they can differ from contract to contract. I think that's going to be an important point to see how some projects will proceed if liability on one party is going to be extreme.
What about your view, Fabrizio?
I think Warwick has anticipated perfectly what I wanted to say. But in fact, under, let's say, if we look at the BRI as a trade facilitation project, there is no doubt that even with the crisis of the BRI, commerce between the European Union businesses and China will not stop. And therefore, the problem will become a different one. It will be a private international law problem, as Warwick was anticipating, meaning that how do you draft a force majeure clause in a contract in such a scenario? And here, I think that we have a role as international lawyers, because if you look at what is used around, you will see that the general practice before COVID was to download, you know, the famous boilerplate clauses that anybody could find on the internet and, you know, stick it in a contract, whatever that means. Well, today, nobody can say that anymore, because if you look at a force majeure clause and you look at the different traditions of legal systems of the world about force majeure, you will be horrified, because you will see that some countries, for example, do not really contemplate that, but they prefer, for example, in England, you have frustration of contract, which has a very specific case law on that. In the United States, there's another idea on well, there are other rules. In France, there's another one. In Italy, we have other rules. So the bottom line is that the best you draft it, the safer you are. And if you draft it today, you need to be very specific. You need to address issues like, what is a pandemic? How do you define, who defines the pandemic? Is it the World Health Organization, or is it the Chinese government? I mean, you have to find some balance, and that's a difficult exercise. But that in force majeure clauses happens also for another part of that, which is the famous war part. What is war? If you look at in common force majeure clauses, they still, you know, request a declaration of war, which we have never seen since the end of the Second World War. And therefore, it's kind of funny to follow this debate, because today, certainly, you will have to organize a trade with China with a lot of more, let's say, skills, and force majeure will be the answer to these uncertainties that are coming up. That's all. Sorry for keeping you.
That was very interesting. Chiara, is there anything that you want to add to this?
I would say no, thank you.
Oh, thank you. So we are only 15 minutes later than expected. It has been very dense. I am really thankful to the speakers, first of all, because of their availability to intervene and animate this event. To those who have been in the public, there was quite a number of you, and I thank you very much for taking the time for joining this event. I have to say special thanks to Stefania Lavezzo, who's also online, who provided outstanding technical support. Grazie, Stefania. And we will now close this registration, the recording, and everybody is free to go, of course, but the speakers will be invited to join a separate channel. I will send you the link in the invitation in a moment, just a few seconds to say a final goodbye. Thank you very much, and see you all very soon.
Thank you very much.
Bye.
Bye. Bye.
Thank you.
Goodbye.
Thank you.